Thank you, Creator, for bringing us safely to Hay River for this meeting of the Standing Committee. Bless us with wisdom and open ears to hear what our guests have to say about the legislation we're reviewing. Please grant all of us a good night's sleep and safe journeys tomorrow. Amen.
Thank you, Julie. We have one item, two items, is Bill 45 and 48, bills of the Corrections Act and Post-Secondary Education Act. Can I have somebody to approve the agenda? Moved by Tom. Everybody agreed? Any declaration of conflict of interest? Seeing none, we'll start right away here. Welcome to the meeting of the Standing Committee on Social Development. I'd like to get the committee to introduce themselves.
Yeah, I'm Tom Bollier, MLA from Tuneda Willade.
I'm Julie Green, the MLA for Yellowknife Centre.
My name's Shane Thompson. I'm the representative for the Nahende. On my left is Jennifer Frankie Smith. She's the committee clerk. And on our right is Glenn Rutland, who's the deputy clerk, but is acting as our committee advisor. And Chris Cotwright here is our media person who is recording this meeting live. So I'd like to thank the staff there for that, and I'd like to thank everybody for showing up here today. Today, the Standing Committee on Social Development is holding a public hearing on Bill 45, the Corrections Act, and Bill 48, Post-Secondary Education Act. The Standing Committee on Social Development is a committee of regular members of the Legislative Assembly. The bills we are reviewing today were introduced by the Minister, given first and second reading in the Legislative Assembly, and then referred to this Standing Committee for review. Legislation is typically brought forward by Cabinet and is reviewed by Standing Committee. Members of this committee are responsible for holding government to account, and one of the ways we do this is by making sure that the proposed laws are supported by the people of the Northwest Territories. It is our responsibility to consult with residents on what they like or don't like about the bills. We would like to hear what your views and comments are, and which will be used by the committee to identify any changes we would like to see made to the agenda or draft the legislation, in which we will then report back to our colleagues in the Assembly. That Standing Committee is holding public meetings on these bills. Yesterday was Fort Smith, today here in Hay River, Fort Province, Betchico, Inuvik, and Tuck, and Yellowknife. We will then report back to the Legislative Assembly on proposed legislation during the upcoming August sitting of the Legislative Assembly. I wish to briefly describe the intent of these bills. Bill 45, the Corrections Act, repeal and replace the existing act. The new act focuses more on rehabilitation and community reintegration of offenders. Operational improvements are made in security, monitoring, case management, programming, and self-training, or staff training. Bill 48, Post-Secondary Education Act, allows post-secondary education institutions to operate within the Northwest Territories. The Minister must consent to the establishment or operation of a university or college. An act of the Legislative Assembly is also required. The Minister must authorize the granting of the degree or offering of any degree programs, and public post-secondary institutions must have minister approval for tuition fees, must regularly evaluate programs, and must submit annual operation and capital budgets. There are copies of the bills on the side table there, as well as plain language copies for both acts. Please help yourself. If you'd like to share your views with us today, please let the clerk know. They'll make sure you're on the list. We're also accepting written submissions by postal mail or emails until June 28th, 2019 at 5 p.m. One final piece of housekeeping. Please remember that all submissions will be part of the official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media. Thank you, everyone, for your patience in allowing this introduction. With committee's agreement, we can open the floor to comments from the public. Does committee agree?
Agree.
Okay, Anybody wishing to comment on either of the bills? Oh, and can you state your name, please?
Kabiri. I only read once, so possibly I was not very thorough, but I picked a few questions that, or issues that I thought I did not find answers to. One, in section 11, there is reference to the decision of the minister being final with respect to applications that may be made. And I'm wondering, does that preclude the applicant from invoking other laws of the land? Or how is the accountability of the minister to be held under such circumstances? If you apply and the minister says no, does that mean you cannot invoke any other registration to challenge the decision of the minister?
Very good question. Thank you. Does committee have?
Thank you for your question. Are you asking about the circumstances of an individual or the circumstances of an institution like a private college or a public college?
No, it's section 11.
Yep.
You know, it's with respect to the applications. You apply, you want to establish a college. I think that's what section 11 is about.
That's correct.
And the process goes on, but if you look at sections 11.7, 12.4, 18.18, this is the decision of the minister. After the minister has received recommendation from the assurance body or the committee he has set, her decision is final as to your application. So that's where my question is. If I receive such a finality, I mean, assuming I think the minister is unfair, does that mean I cannot go anywhere else?
That's how I read this. Yeah. It doesn't give you any more options, such as appealing it to a court.
Right.
I would have to seek legal advice to find out if that is in fact the case, but the way I read it, and this sentence appears in several places in this act that has to do with establishing different kinds of institutions, it says that the minister's consent is final. I'm just going to ask Shane to add on to that.
Yeah, so these decisions are made based on standard of procedure fairness. And there is a committee that would make recommendation with to the minister, and she would then take that into consideration moving forward to make the final decision. That is my understanding of the process, and that there wouldn't be a review or appeal process under the proposed act presently.
Yeah, then I would submit that is unfair, because their accountability should be ensured. I mean, it offends the laws of natural justice, especially because, you see, the minister refers an application to a committee or to an assurance body, but the decision of that committee is not binding on the minister. So even if it said give, the minister can say no. The only one which is binding is that a minister cannot authorize establishment without the approval of a committee. But the reverse is not the case. The recommendation of a committee is not necessarily binding on the minister. So I think there are issues of natural justice. And also, if you look at the section that 1.4, with respect to certificate of registration, the minister is supposed to give reasons for rejection, but the same is not provided for colleges. So I think there would be need to give reasons as similar to what is provided in that 1.4 for colleges. The other, I don't know if I should say.
So what we understand as well, where a decision has been made with less engagement between the department and applicant, such as the case of vocational training programs, there will be a review and appeal process in order to allow that applicant to address the reasons for the decision. So that there is what we've been advised, is that there is a little bit of a process of explaining the process, why it was turned, she decided or he decided not to approve it. But yeah, that's what we've been advised of right presently.
I have a question. Would you make what would your recommendation be? So the laws are written and somebody at some point has a final say. Inside this law, it would be the minister. If that seems like an unfair process, and even though there is oversight in the Legislative Assembly, but the way it's written, the minister has a final say. Have you ever seen any legislation that has something that works better?
I don't know whether I can remember properly.
You speak in the microphone.
Whether it is, I have read the laws on the natural resources or possibly the Information Act, that it can be phrased without prejudice to any other remedies that may be available to individuals to pursue with respect to the laws of the land. Because then in that case, it will open for you an option. You can petition the courts to challenge the decision of the minister. Because I don't know, as Madam said, they need to look for legal advice, because the lawyers can say whether that finality precludes your right under other laws of the land that allows you to seek grievances before a court of law. Because the problem is, if it is understood as final and you go to a court of law and the court of law decides to say, no, the act says the minister's decision is final, you have no remedy. That would be the problem.
That's a reasonable request, and just hearing that, maybe be cabinet that would make the final decision instead of just the minister, but we'll bring that forward as one of those recommendations.
Yeah.
Your next point?
Yeah, I thought it's some clarification. When I look at the establishment of these post-secondary institutions, Section 11 is saying how people can apply for that. But I'm wondering, what about with respect to establishment of public institutions? Because Section 11 seems to be addressing private or non-public institutions. But how are public post-secondary institutions to be established under this Act?
I thank you for that question. I think Section 11 is specifically about a university, but there are other sections in this bill that have to do with establishing private training institutions. That's Section 27, and private vocational training, which is Section 34. So the way that's outlined, they would not be publicly funded, but there would be some accountability for the quality of the programming that they're provided to the students. Does that answer your question?
Yeah, the question is, assuming the government of Northwestern Territory wanted to establish a post-secondary institution, how is that to be initiated under this Act? Because this Act tells me, if I want to establish an institution, or a group of us want, we apply to the minister.
That's right.
But what about if we want to establish, the government want to establish a Northwestern institution, that is a public institution? How is that process to be initiated? Is that process to be governed by this Act?
My understanding, and I think Shane mentioned this at the beginning, this is very big picture legislation governing the establishment of different kinds of institutions. And if there was a specific institution that was going to be created, it would have its own legislation. So
Okay.
for example, right now we have the Aurora College Act.
Yeah.
And so if the government is going to create a polytechnic university, which has been discussed, it's my understanding that they would have to bring forward legislation that that we would review that talked about how that was going to happen. Yeah.
Yeah, they're treated the same, like whether it's the government or somebody else, it would be, the process would be very much the same.
Okay.
Good? Okay, any other questions? Awkward silence there. Maybe we can ask some questions and maybe then get some things going here. So, I'll, if you wouldn't mind about asking the question about community or community groups there about this.
Oh. Okay. Yep. Looking at the Correction Act, there is a section in here. I'll just say, while I'm looking for it, the Corrections Act, this is the first new one in more than 40 years, and it's taking a totally different approach to corrections where there's some more emphasis on rehabilitation and healing rather than on punishment. Although, of course, if you're in a correction facility, then that is a punishment. So one of the things that the Act contemplates is having a community advisory board, which would assist in the administration of the Act, the regulations that go with the Act, and other matters to do with personnel and inmates. And this advisory board would be comprised of members of the public, including Indigenous people, and they would be paid an honorarium, reimbursed for their expenses, and they would have fairly broad powers to see what was going on in the correctional center and to make recommendations about what they see. So my question for you as members of the community of Hay River is whether you think this would be a useful committee to have in your community, and whether you think there would be any difficulty finding people to be part of that board.
Sorry, can you say that again? Like, what you're kind of looking to the, what are you saying about the board in Hay River, like going with what they have?
So I'm in the Corrections Act, and I'm on Section 4. The Act envisions setting up community advisory boards, and it's my understanding that would be in each of the communities with a correctional facility. And that and these community advisory boards would be comprised of members of the public, and they would have this advisory capacity about the operation of the correctional center. So my specific question, because I know that communities have a finite number of people who want to volunteer in these kinds of capacities, is whether the community would be interested in being part of a community advisory board that relates to the correctional facility that's here in Hay River.
No, go ahead.
Back of the church. Ray, were you going to speak to that?
I was just trying to figure out what actually they were trying to say about the
Okay. Well, I'll come back with an answer to Miss Green's question there. So we've had the correctional facility, South Mackenzie Correctional Center in Hay River for many, many years. I would say it's a very valued institution in terms of it creates employment. It allows people who are incarcerated to stay closer to family and communities for people who are from the South Slave area. Probably doesn't help those who aren't, but so I think it's a very valued institution. And as such, my perception is that it's not on most people's radar. It's an institution that's very, it's strictly governed and managed and so on. And again, just around the areas of confidentiality and protection of privacy, not too many people in the community would have a lot of opportunity to interact with this institution. To some extent, yes, I'm sure there's programming, cultural programming and stuff where there may be, I wouldn't be familiar with it all, but there could be, people in the community that are involved. I think it could only be a good thing for there to be more community involvement. I mean, it would have to be organized and carried out, in specific ways because of the nature of the institution. But I know that over the years, for example, people have gone in on Sunday afternoons and clergy, for example, and visited with inmates, and that's been a fairly structured thing. And I think that that was a good thing. There's been a very strong cultural program as well, with actual staff working with the inmates on the kinds of things that Julie's referred to, that this act anticipates to improve, and that is healing and rehabilitation to reduce reoffending and to help people. I mean, there's no sense in warehousing people if you're not going to do something with them. You have a really good opportunity when people are incarcerated to do something positive and create a positive experience for them, as much as being incarcerated can be considered positive. I think that needs to happen. So I'm only one member of the community, but I would say that there would be people in this community who would be interested in becoming involved in some way, and perhaps the structure of that would have to be laid out, and the rules around that would have to be laid out by the people who are in the management on the day-to-day operations of the facility. But my sense is that yes, there would be people who would be interested, and they do have already like good work programs, work release programs, things like that. I know our company has worked on occasion with inmates that were allowed out to work during the day, and we had a very it was a very positive experience for the most part. So even that allows people like, say, like my husband, who's working with one of the inmates who's out, to allow for some one-on-one positive input into somebody's life. And even one inmate particularly said, well, I want to come back to Hay River. I'm going to come back and work for you guys. Come to Hay. I mean, it didn't turn out that happened, but it was, I said to Rick, it sort of felt like we were back in the days of managing the group home. I mean, it was somebody that had gone through a difficult time, and then we were allowed that opportunity through the work release program. But there could be other things whereby people in the community would like to be involved. So, long answer to your short question, Julie. Yes, I think that there would be. I think there would be people in Hay River who would be very interested in that, and I think it would be worthwhile. That's my opinion. Thank you.
Anybody else, or any concerns?
I tend to agree with that statement. I mean, it can't be a negative. Ray Levesque, I just agree with what Jane was saying, that it has to be a positive for the community and for the members of the community. But at the same time, is it my understanding that sentences served in the Northwest Territories are generally 2 years less a day? So these would be kind of short-term programs that we'd be looking at, trying to help implement and be a part of?
Yes, correct.
Like, I understand it's the whole new touchy-feely, we're doing all the good stuff now prison system. So this is kind of what I was wondering, what happens to our residents that end up going down for longer than the 2 years less a day? Because I seen something in about parole officers and that. So when they come back and get reintegrated into our society again, are we helping them as well? That might not be benefiting from what we're trying to do in our territorial population in the federal system. See.
That's really a good question. This act doesn't say too much about reintegration of offenders, whether they're in the NWT or they're coming back to the NWT. But that's obviously a very key point about what happens after they're released. What are they being released to? Where are they being released? Do they have a home? Do they have a job? Do they have any resources of any kind? I don't think that the Act contemplates that. It's really about the correctional facility itself, but that doesn't mean the questions aren't relevant. They are very relevant.
See, it's just what I was reading here is key components of the new Corrections Act, and one of them is roles and responsibilities, including those of probation officers and persons in charge. So to me, that they're going to be dealing with probation officers for a long time. So I would hope that with this whole new act, that it's more than just help in the facility, to help them once they leave the facility to not reoffend, to get back into something, because there's no support for them out there.
Yeah, I agree with you, and I think part of the process that my understanding is that would be looked at is that I know from our standing committee and when we were looking at it was the integration of the person back into the community, whether it's addictions, whether it's fed time, whether it's territorial time. We're trying to help those people become productive citizens, and that's the important part of it. And I think we would be working, because if you have probation officers, they're going to be territorial, but they're also going to be working with constituents or residents that come from the federal.
And that's what I'm kind of getting at, is it's great to say that we're going to modernize our correctional facilities here. We're going to be great. It's going to be some kind of European model, and people getting out of the federal institutions come back to their communities, lose their minds, because we're not helping to support them like we're proposing in this for our inmates that are here housed in the territories.
Yeah, but I would probably say that when people are coming back from feds, they're still going to have to probation. They're still going to have the people in the system, and we'd be working with them. I mean, it might be a longer process to help them understand what's going on. But right now, I think majority of our residents are 2 years less a day. I would say probably 80, 90%, maybe 95% of our inmate population is get less than 2 years minus a day. I know as a JP, in my past experience, 4 months or 6 months was the max, and so again, it was a shorter period of time. Some of I know there are residents that are doing federal time, but I'm assuming that they would have programs down there as well, and that when we come back, they would still be working with our system, and that would probably mean a little bit more work with our probation officers and that to get them to understand what we're trying to do to help them.
So one of the things that this new act focuses on is providing programs and services to inmates so that they are able to use the time while they're in jail constructively to upgrade their literacy, to learn life skills, and so on. And that can sometimes be challenging because of the duration of the sentences. Most of them are a lot less than 2 years, less a day. So do you have any thoughts about what kind of programming could or should be offered to inmates? I know I'm kind of putting you on the spot, but I thought that since you'd given some thought to reintegration, you might also have some thought about programs and services while they are in the jail. Thank you.
Anybody? Okay.
Again, Ray Levesque. I'm pretty much of the opinion that once they're in there, you have to find out why and what are the skill levels that they have going in there. If we have individuals that are fetal alcohol spectrum, you're not going to try to set them up with a university degree. We got to figure out what we need to do to help those people and give everyone the best chance at reintegrating back into society, whether it is literacy programs, whether it is anger management, whether it is the sexual frustrations that a lot of them have towards individuals, the counseling, the trauma from residential schools, whatever that may be, but it has to be identified. You can't just say, okay, now you're in this program, and, well, I didn't want to retread tires.
I think that any kind of community support really needs to have,
Maddie?
Maddie McNeil, has to have some Indigenous people involved, because I'm an educator, and I know that in our schools we don't have a lot of Indigenous people, and I know what happens there. It's really difficult to do the indigenizing the education, because the people who come from wherever they come from don't know about that, and so they teach how they have been taught to teach. And I think the same kind of thing would happen in a correctional institution, that there needs to be something that they feel familiar with and some people that they trust. And I think that you need to have, I'm assuming that there are a large number of Aboriginal people who are incarcerated, and so we really need to also plan things that are going to work for them, not something that came from a textbook in Alberta, in Edmonton.
Tom Bolio, I'm interested in some of the stuff on the federal questions about the federal penitentiaries. I think they have pretty good programs. I think that from the federal, if they're doing federal time for some of the serious crimes you spoke on, they would be also doing lots of programs down there that probably have better resources than our ability to offer programs through this act here. This is focused on all of the people that don't commit a crime serious enough to get more than 2 years. So I think the programs are geared to that. There's not a whole lot of people in these systems that have the complex issues. I agree on the fetal alcohol spectrum disorder. I think they need to target some of that for sure in the programs, but the problem now is that even federally they don't know the prevalence of fetal alcohol spectrum disorder. So not understanding the prevalence, even though they may suspect something, to identify it or else approach somebody to say maybe you have fetal alcohol spectrum disorder could be a bad mistake. So it's hard for the government to identify that and then put programs towards that. But I know the federal system have their own, and they go on parole, not probation, and they come out of the federal system. Probation is something I think that's the officers work for a GNWT are more in tune with this act rather than the federal act.
Okay. Jane?
I just wanted to respond to something that Maddie McNeil just said, and that was the around the cultural presence or prevalence of people who are working with people who are incarcerated. Now, I cannot speak for the whole Northwest Territories or like North Slave Correctional Center, but from my understanding, when we used to discuss the affirmative action policy, for example, there were certain activities or departments in the government that had for many years far exceeded what targets were in other departments. And just from living in Hay River for 45 years, I mean, that's another very proud heritage of this facility that I'm talking about, that our community, although we may not be too involved, we take a lot of pride in, it was the presence of people working in the correctional facility in Hay River who were Indigenous people. I don't know if it's still as high as it was, but I know, and maybe Mr. Bolio could help me out with that, if those statistics or numbers have changed. But is that not true, that there was a very high percentage of people who were working in the corrections facilities who were Indigenous over the years, when we were looking at setting targets in other areas where there wasn't that? I mean, I thought at one time it was like 80%. So anyway, just to Maddie's issue, because she's talking about teachers coming in from the south and don't have any or don't have as much cultural awareness. But I think that is one area where we've had considerable success with that in the correctional area.
I guess the last time I actually looked at real numbers that were given to me on the affirmative action, it depend. I think the correctional North Slave, I think, has a lower number. I think South Slave has a higher number, and but it hasn't. I don't think I've seen actual numbers of the thing for about 40 years. So yeah, since you were there, we didn't bother to look, I guess. But yeah, I think, well, I no longer have easy access.
Maddie McNeil, I guess I worked in a school, and I'm an Aboriginal person, but a school works in a certain way that doesn't necessarily support bringing in Aboriginal stuff. And I don't know what it's like in a correctional center, but I'm wondering how the people who are Aboriginal are involved in determining what kind of programming that they might be able to do with the inmates.
Denica Day's got its own system in the school, and it's difficult for us to even talk about. We're not equipped here to respond to anything to do with the school. But this act is trying to incorporate some of the culture and so on, so that people don't. I don't know the word, Shane. Shane will say it.
What's what word?
Repeat offenders.
Oh, recidivism or?
Yeah, recidivism. Yeah. Right. Right, and then so that's what they're trying to reduce, and with this is one of the I think one of the objectives of this act, and then yeah, it seems like there's a lot of culture in that in the schools, but we don't know the level of it here anyway.
I was Maddie McNeil. I was talking about within the jail here, like the people who work there, how involved are they in making some determinations in terms of what kind of programming would, especially cultural programming, that they think would be good to have with the inmates?
So I think with the new act and being repealed and replaced, that's part of the direction we're trying to go, is we're trying to make it more culturally relevant. Right now, if you look at the number of inmates that are in the corrections, whether it's here or Fort Smith or in Yellowknife, a high percentage is of Indigenous heritage, right? And so we're trying to make it more relevant to their needs. The biggest challenge we have besides this, though, is when people are remand. So when people are being remanded, they're not getting anything. They're like, they don't get part of the training. They're just in there, right? Before their court cases are brought forth. And so that there is one of the challenges that I see, is that, you know, it's great that, you know, that once the person is in the system and then we're trying to help them, but if people are being remanded and they're not able to do things like, you know, work experience, they're not allowed to do that. They're not allowed to leave the facility. So, you know, how are we helping them? And so that was, you know, a question that I've heard before, and we're trying to understand a little bit better. But I think the Act is trying to move forward to a more positive step. And it's reintegration of the, you know, the people that are in the correction institutes. And I think I give credit to Julie, and it's Ms. Green here. It's about, you know, first of all, if they come out of the system, where are we going to be able to put them? You know, transitional housing, because if you put them back into the same environment, after a while they're just going to get back into the same thing that they did, right? So if we have transitional housing out there, we're able to develop that and then help them, you know, work on getting the necessary skills that they get. They're not all going to be doctors, but they're all not going to be, you know, waitresses either. There's a skill set that we need to work with them on. And then the other thing is then after that is to get them a job. And, you know, because once you got a job, there's a pride, and then it's all of a sudden there's a whole, you know, they look after their homes, they're looking after themselves, they're looking after their family, and then it's just a spiral effect going up instead of downwards. So those are some of the challenges that we see. And we had the privilege of going on a tour for the addiction facilities. And again, that was what we saw, was where, you know, you go do your treatment, but what happens after? What's the aftercare? Where's the home? Where's the support? And so that's some of the things that we're trying to look at. But I mean, I know digressing a bit, but yeah, so that to me is what part of the Act needs to be addressed, is, you know, I think it's working well. They've looked outside the box with this. So, but again, though, we're trying to make it better, because at the end of the day, we don't want to see people in the system.
Thank you for your question, Maddie. I'm going to have a go at answering it as well. The correctional centers are still going to be jails with a hierarchy, with segregation, with strip searches, with a lot of rules. They are still going to be that. And you may have a warden or a director of corrections or other senior staff who are Aboriginal, but I don't think that their indigenousness, if I can use that word, is going to be apparent in the standard operating environment. Where it is mentioned in the Act is with respect to that community advisory board I asked about, and also in the section under program and services. It says specifically that programs and services offered must reflect the needs and culture of offenders who are Aboriginal. And so there is some possibility to make the programs and services more culturally relevant, but you are kind of grafting that onto an existing structure. So what I understood you to say is, schools are schools. You can tittle around with the curriculum to make it more appropriate, but it's still in the context of a school. And I'm saying to you, a jail's a jail. You can have smudges and talking sticks and other kinds of Indigenous content, but if you are a risk to yourself or others, you're still going to go into segregation. It's still a jail.
Jane?
Okay. I just came to this meeting to watch. I wasn't really going to say anything, but you know, this is kind of opening up an interesting discussion. So I agree somewhat with what Julie is saying, but I also agree that well, I shouldn't say none of us, someone here works in the corrections facility, works in the corrections area, but Most of us are basically on the outside looking in. But from having been an MLA before and the many tours of the South Mackenzie Correctional Centre, at least, I can tell you that the cultural component was a cornerstone of their programming. So there could be classroom training, there could be helping people get their GED, there could be life skills work, there could be work programs, which, just kind of contributes to the community but teaches people how to work to some extent. So I hear what you're saying, Julie, but I do think there is something to be said for the majority of the people who are being cared for or in these facilities, seeing people that they relate to and reflect their own communities, their own culture. Yeah. I think that is a benefit. Everybody agrees with that. But I think the interaction with that staff is probably more than what you think. Like, I know, for example, if an inmate has a death in a family, there could be a corrections officer that will actually escort that inmate back to their home community to attend, critical things such as, a funeral or, so I know that goes on. So it's not all that clinical as you might think. There is interaction, and I do think it is important. And like I said earlier, I think we've had a fair amount of success with that in the South Mackenzie Correctional Centre. With the representation amongst the employees and the programming, like I said, key cornerstone of the programming there has been a person working there who has, done things with traditional activities for many years. So I think we're kind of doing okay on that front. Like I said, and maybe I'm also on the outside looking in, don't know what I'm talking about. But that's my perception from my years of touring the facility and having knowing people that have been incarcerated here. So I don't think we can understate that. Can we flip back to the other act just for a moment? I just have one quick comment on that. So from what I understand, just from reading the plain language overview, it's about NWT post-secondary institutions. And I just want to go back again to, we're not going to have every type of training in every type of institution located in the Northwest Territories. So it seems like that's where this particular piece of legislation stops. It seems like that is confined to the post-secondary institutions in the Northwest Territories, accreditation and quality control and all those sorts of things. But I think we need to go further than that, because I think we need to be thinking outside of the box in terms of post-secondary education for NWT students who have to leave the NWT to acquire that education. And I remember when I was MLA that I had a constituent in Hay River who wanted to go to British Columbia to an Aboriginal policing program. No, that's not on our list. You can't go there. Come on. How could that have been anything but a good thing to have checked that institution out and approved that as one that would be eligible for a student and student financial assistance, et cetera. So I think that in the Northwest Territories, we have to be practical. We're not going to have training for every type of career that NWT residents want to pursue. So we need to have a way of providing accreditation to private. I think that was a private college that this constituent of mine wanted to go to. Aboriginal policing. It's great. The RCMP probably, in their history that I'm aware of, have only had one program that was specifically directed towards Aboriginal special constables, community constables, Aboriginal community constables. Only one. We have a member in Hay River who went through that program in Regina and has served our community ever since. So things like that, I'm just using that as an example. So I don't even know if that's within the scope or the mandate of this particular legislation, but I think we have to be realistic. You're not going to be able to have every possibility. And the whole thing of education has just changed. You just got to think outside the box. There's so many different ways now that people acquire education. Look at Dechinta University on the land. You look at some of the online educational opportunities now. There's so many different things so it's a big mandate for somebody to take care of, to make sure that we are serving the residents of the NWT who want post-secondary education that is not available in the Northwest Territories. So like I said, I have no idea what that has anything to do with the legislation, but that's my comment.
Thank you for that. Section 20 of this act talks about authorizing other institutions to provide education for, that they will be recognized in providing education for residents of the NWT. So, you know, I totally take your point that you can't finish your nursing degree here, you can't finish your social work degree here. They have partnerships with other universities. So they do envision continuing those partnerships in this act, and there are some specifics there. Your point about not everywhere is acceptable, I've heard that in the course of my constituency work, that people have applied for programs and then they've been turned down because the program is not recognized by the government, and so then there's no student financial assistance attached to it. So I don't see that the government, that this act sort of provides a way around that. They still seem to have agreements with institutions that they're providing a standard of service that the government itself is prepared to pay for. And I want to say that I take your point on the correctional center. I'm not trying to be flippant. I value and I'm happy to hear that Indigenous people are a key part of the correctional center here. But I want to tamper any expectations that this jail is not a jail, or under the new act that this jail won't be a jail. Like, it's the standard operating will be what you already know it to be, and hopefully with better programs and services. Thank you.
You good? One more?
Madam McNeil, I think that it's important, if you are going to have a committee in the town, that they're really aware of what kind of parameters there are of things that can be done in the jail. If it is a jail, and we know there are certain kinds of rules and regulations, they have to be really aware of that. And so, taking that into consideration, what can we do differently, and what can we incorporate or change and still keep it as a jail? I think that's really important, because I think sometimes we're not aware of that, or may not be aware of it, and then we get frustrated because we want to do something and we can't. And it just seems like, well, gee whiz, why did it get me on this committee, you know? So I think that's really important that people understand that.
Thank you. Is there any other comments from anybody else? Mr. Simpson. And by the way, he's the River North MLA. We should introduce him and thank him for coming out to our committee meeting here today. And he's an alternate to our committee as well.
Thank you. And that's why I was going to keep quiet, much like Jane. I just came here to listen, but I had to speak up. To the very first point that was brought up about the right of the minister to reject an application to create a university, and the fact there is no appeal process, perhaps the committee might consider that the minister is required to give written reasons as to why, because it doesn't even go to the committee. The minister has the right to just outright reject it, and at the bare minimum, there should be a requirement to provide written reasons. There's also Section 56 of the Act is a clause that allows the department to gather information notwithstanding the Access to Information and Protection of Privacy Act. And for the most part, they're fairly narrowly defined instances in which they can collect that information, or purposes that they can collect it for. But I have some concerns when you say notwithstanding this Privacy Act, which is, you know, it's a big act. There's been a lot of time spent on ensuring that it does protect the privacy of individuals. So I have concerns when you say that that act doesn't apply to this section here. So I think the committee needs to look into that, and just make sure you do your due diligence when it comes to that. I've been getting messages on my phone during this from people who've been watching the live stream, and there's support for the community committees, because there's been, I think corrections, there's probably about 40 people who are employed there, And we've had that place a long time, and so there's a lot of people who've come through there. There's a lot of people who are now retired. There's people who were corrections officers. There's people who were teachers there. There's people who actively participated. And so to Julie's point, yes, there would be people who are interested in that, even just people who have worked there. I think I might have some other points, but if I do, I'll raise my hand again. Thanks.
Thank you, RJ.
Just a general point. I think the Act does a good job in section 7 and 8, where it provides for quality assurance, because quality is critical to the success of post-secondary education. The problem is that that body is subservient to the minister, who is also the person who is authorizing. And I was wondering whether it would not be a good idea to have a body that is at least semi-autonomous, if it is the one to provide for the superintendence of the quality of post-secondary education that is being provided. Because as it is now, the minister appoints the chairman, the vice chairman, and the other members. So there need to be a mechanism to control for an incestuous relationship between that body and the minister, if we are to be assured that there is proper quality of higher education that is taking place. Otherwise, as of now, it appears the minister is the pivot of everything. And what the minister considers to be quality education is then what passes. I think it would be good practice to have a separate body that can give a critique to what the minister is providing. Then in that case, and a body that should also be available to the public who can make presentations to that body. And then even if the minister doesn't take the recommendation, at least in terms of institutional making, we are assured that we are able to get all the reasons out there in an objective manner. Because I'm not sure the minister can appoint her enemy to give recommendation for an institution if she has an interest in that.
Yeah, thank you for that comment. I share your concern. I don't see that these quality assurance bodies, as outlined in this act, have very much independence at all. And if they are going to do quality assurance, they should have independence. So yeah, I take your point on that. Thank you.
Jane?
One more comment. Again, I'm not really sure how it fits into the discussion of this legislation that's being contemplated by the standing committee tonight. And by the way, thank you again for having Hay River on the list of places, of communities that you would visit and seek input. I know sometimes you don't always get the best turnout. It may be discouraging, but thank you for including Hay River again. Shane had mentioned aftercare. That always brings up an interesting topic when you talk about people who are incarcerated. And when I served in the legislature, we had a member from Mackenzie Delta, David Krutko, who spoke of the Clone Day Healing Camp continually the whole, I don't know how many years he was there, 12 years, 16 years. He talked about that because the government, our government, for whatever reason, did not see merit in having a family-based healing program. Now, maybe that was more related to addictions, but it could be. So I'm just going to quickly tell you an idea I just want you to take back there. In the matter of people who have gone away from their families for rehabilitation or who have been incarcerated. I know there's models out there. We need to look at other jurisdictions and what they're doing with that. My personal experience recently has been with the North Peace Tribal Council out of High Level, and they manage programming for a large number of reserves around High Level. And they are undertaking a family reunification program. So the idea being that if one parent, both parents have been away from the family for a while, they do not go right back to the community. They do not go back to their home. They come together offer all kinds of support, programming, counseling. The whole family comes. They've been doing this out of a hotel in High Level, and that's why they approached me, because they said, look, we need to do this someplace where we can have our culture represented. You know, the Mirage Hotel in High Level is not going to let them put a teepee up in the front yard, okay? I mean, I'm using that as an extreme example, but that is one that they mentioned, okay? So they wanted to get something a little bit off the beaten trail. But isn't that a great idea? For a period of time to bring a family together, so they eat meals together, but during the day there's programming for the children of these folks, there's programming for the individuals, there's counseling, and then instead of just sending that one person off from the correctional institute and saying, all the best, you know, hope it works out well for you out there in the real world. I mean, why don't we have something like that in the Northwest Territories? And we have had Aboriginal governments who have brought forward models like this over the years. So I know this is way outside of what you guys are here to hear tonight, but we could never seem to find the funding or the support from, even when it came from grassroots places like that, to support that idea. But I think it's important, so I just wanted to put that in there because Shane had mentioned the aftercare and the after support to reduce the very things we're talking about, reoffending, recidivism, all those things. We have to have some next step programming as well. Thank you.
Thank you, Jane. Just go back to the question prior. The department, it would be part of the regulations, and so what they're looking at is establishing a quality assurance body, similar to what is, you know, they've done a cross-jurisdictional review, and right now they've looked at other jurisdictions that do it, and so the basically it's an arm's length quality assurance agency that reviews and makes recommendations from that. So it's away from the minister. It is that they're looking at that as part of the regulation. So it's not in the act itself, but it's going to be part of the regulations that they're looking at. So it's been addressed previously, and they're looking into that as well. Any other comments? RJ.
Thank you, and I have some final comments on the Post-Secondary Education Act. There, in addition to colleges and universities, there's also talk about private institutions and vocational training. And I just want to make sure that the committee is aware of the concerns regarding sort of the overregulation of everything these days. And I noticed in here that there's requirements to apply every year for certain, to be able to provide certain types of training, or rather to be recognized. There's quality assurance things without any sort of committee oversight. There's a lot of red tape, it seems like, and perhaps that's what's already in place. I'm not sure. I just want to make sure that the committee is aware that, you know, we already have there's the Marine Training Institute here, there's the Northern Farm Training Institute here. I don't want this to put those places out of business. I don't want it to make it more difficult than it already is for those places to operate, because they actually do good work. And the last thing we need is any sort of roadblock for them. So has the committee put their mind to that? And does it know how this act, if it takes effect, will affect those institutions and will affect organizations like Deshinta? Thank you.
I guess the impact will be if the department doesn't consider it to have the accreditation to be a university or offer degree programs.
Yeah, and right now it's the word university. Deshinta, I've seen some information out there. They've changed their name, their title. It's about the ability to use the word as university, and it's working towards degrees and that. So that there, your other question about NIFTY and the marine training, we haven't looked at that, to be honest with you. So it's something that we need to look at, because again, as I explained in Fort Smith, sometimes we just see the forest, we don't see the trees that, and this is why the consultation process does it, allows us to see the trees and some of the challenges that we do miss. And so, you know, we appreciate that, and we will be looking into those as well, asking those questions, so, because we need to make sure it's done right. As you've been on the road for a few bills, and some of them are not that well done, so that's why we're trying to make sure we get things worked on. So I thank you very much for that, RJ.
I have a question for you again. I asked you a question before. Inside the act, it does sort of it gives ministers sweeping powers, right? And then there's other acts like that, right? We recently came across a situation in the Legislative Assembly, right, where minister has sweeping powers to make a decision. Do you think that a recommendation to say that the minister in consultation with cabinet will make those decisions, just adding in consultation with cabinet in all the areas where the minister has sweeping powers, you think that would resolve the issue?
Maybe a committee of the Legislative Assembly other than cabinet, because cabinet, they are colleagues, and here what we are interested in is accountability. And the cabinet will not hold their fellow cabinet minister. So I would rather, as a member of the public, she consults with a member of the Legislative Assembly. I have looked at another jurisdiction where a law was written in consultation. And this was between the president and the prime minister. So the president would talk to the prime minister and say they have consulted. And so the question arose whether consultation means consent. So if we are trying to push for accountability, it would be better if the Legislative Assembly is involved other than the cabinet. At least because we know there is a committee of the Education Committee or something, and they deal with the cabinet and all the like. And we are talking of a very critical issue, because what we are dealing with in this is the provision of a public good, which is not open to everybody. It's not everybody who is thinking about higher education. And so if we get it wrong, so many things will be wrong. So that's why I agree with you, but not cabinet, but the committee of the Legislative Assembly involved in education department.
Okay, so a regular citizen on a committee wouldn't have the authority to administer an act for the government. So if they had a cabinet that's administering the act, once this act is through, you would have maybe what might even be possible would be regular members from the Legislative Assembly on committees, because if you just appoint a committee outside of the MLA group, then you're hiding who's making the final decision from the public, and the people that are not voted on by the public are making final decisions. It should be the elected officials that will make that decision and stand up in the Legislative Assembly and be held accountable for it.
Yeah, that's what I mean.
Yeah.
Committee of the Legislative Assembly. I am assuming that in the Legislative Assembly, there are members, MRA, who are in charge of various departments, education, let's say environment and the like. So there is a committee that deals with educational matters. And that can look at what regulations the minister, that looks at the regulations the minister is putting in place and the like.
Well, that's us.
Yeah, that's
Right. We are that committee,
Yeah.
but we don't have the staff to be able to administer an act. Like when the government approves an act approved by all 19 members of the Legislative Assembly based on majority vote,
Yeah.
then that is given to cabinet or executive council for them to carry out the act. We don't get back in again through the administrative process as regular members, but we get to see the budgets, we get to see we get to do this, consult on the act prior to it being approved, but we're not going to be able to carry out the act as regular members unless you do see a complete philosophical change in the way the assembly is run right now.
Ray?
So with the minister having the final say that they can grant this university or not, and not allowing there to be another layer, say, in the courts or something, does this not set us up for something where, say, just for an example, like a religious school was going to be set up, and the minister said no, the act says that's final say, that's a breach of my charter of rights and freedoms, now we're going to federal court to have this overturned. Like, there's an absolute, everyone's thinking just nice DeChinta Bush University and all the rest of it, but there comes some real questions about other forms of university that I don't think we're taking into consideration or account when we say the buck stops with the minister. There's nothing there that says, okay, you can go to court. I know there are other acts that say, okay, if you don't like the decision of the minister, now go to the Supreme Court, the NWT. Boiler Pressure Vessels Act is one of them. So I do think that there needs really to be something in there that if there's suddenly a college that somebody doesn't like, marijuana, even though it's legal, if the minister is opposed to that, he can just say, that's it. Well, now that's a breach of my charter rights because it's legal. And so I think maybe that the committee does need to go back and say we need to look at another layer of not just having the minister say this is final say, whether it has to go to the Supreme Court or something.
RJ? And then Maggie.
Yeah, that
Maddie,
section talks about regulations, basically. The minister can deny the application pursuant to the regulations. And I understand there's always a need for regulations, but that removes the oversight function of this committee, because this committee has no say over regulations. So sometimes it's good to leave things to regulations, sometimes it's good to flesh it out a bit more in the act, and perhaps this is a situation where you might want to flesh it out a bit more. Just something to consider. Thanks.
Okay, thank you, RJ. Thank you, Ray. Oh, no, she was just stretching, sorry. Is there any other comments or concerns about either of the acts? Okay, seeing none. If there's no further comments or presentations of the public, do members agree that this agenda item is concluded? Agreed, thank you. On behalf of the committee, I'd like to thank everybody who joined us here today. As MLAs, it's a privilege to be here and to hear directly from you. When we make our final report in the upcoming sitting of the Legislative Assembly, we will highlight the feedback we received during these meetings and from other public submissions. If you still have questions about the bills or we want to make a written submissions, please talk to our committee clerk, who can also, or you can also visit our website at www.assembly.gov.nt.ca. I will now adjourn this public meeting. I'd like to thank every one of you for coming out tonight. Thank you.